Thank you, everybody. I'm very pleased to be able to speak to you today. I'm going to talk about the advantages and disadvantages of different testing methods in terms of the legislation and policy. Some work that we're doing comes under the banner of our road safety strategy to 2020 called Safer Journeys. The Safer Journeys strategy, I'm not going to go into in great detail, but it's based on a safe system approach where we try and use a number of initiatives to lessen the severity of harm resulting from road crashes. And it's based on the 4 pillars of safe speeds, safe vehicles, safe road use, and safe roads and roadsides. The one that I'm going to talk about today is more the safe road use, because that is relating to substance impairment. As the Minister mentioned this morning, Parliament has just recently passed the law to reduce the adult drink drive concentration for adult drivers, those are people aged 20 and over, from 0.08 to 0.05. We've currently got 2 reviews underway. One is reviewing the sanctions for drink driving, and there's a number of activities or components of that. And what's probably more relevant directly is we're reviewing our drug driving law, and that's looking at particularly drug testing technologies, drug enforcement models, and some of the other issues that I think people have mentioned so far today. I just thought I'd describe what New Zealand's current drug driving regime entails. It's not a random testing regime, and by that I mean that in terms of the correct legal definition, the police cannot stop and test a driver for drugs if they don't have good cause to suspect. So it's the element of requiring good cause to suspect, which means that it's not a random testing regime. We're using an impairment-based approach, which has 3 steps. So there's good cause to suspect the use of a drug or drugs. Then there's unsatisfactory performance on the compulsory impairment test, which is a test of behavioural assessment, of behavioural impairment, and then the presence of at least 1 qualifying drug in a blood specimen. We've also got an offence there, which is driving under the influence of drink or drug or both, to be incapable of proper control of a vehicle. It's an old offence that was there it's been there for a long time, but it's still there. We're not commonly used because it can be difficult to prove the capability aspect of it. There is another offence there that was included in the bill when it went through quite late in the process, and it's a presence-based offence which deals with for hospitalised drivers only, and that's with the presence of a Class A drug, which is usually methamphetamine in a blood specimen. This is to deal with the problem that we have had when a person who's injured in a crash cannot be required to do a compulsory impairment test. Now, I was going to talk just briefly about 3 main approaches: the impairment-based approach, the per se limits, and the presence-based testing. Just some advantages and disadvantages. I mean, the impairment-based approach, I guess, focuses on impairment, the primary objective for road safety. And in our regime, it sequentially builds a case against the driver. So you've got to have good cause to suspect before you can require the person to accompany you to, the police can require them to accompany to the police station to do the compulsory impairment test, and then the performance on the compulsory impairment test has to be unsatisfactory before you can require the person to undergo a blood test. And under that regime, it does comply with the New Zealand Bill of Rights Act, which specifies certain rights for people, and that's not to be subjected to unreasonable search and seizure, which requiring a person to require a specimen of bodily fluids can be search and seizure, and also the right not to be arbitrarily detained. So if you're going to stop a person and detain them when they haven't been suspected of having committed an offence at that point in a random testing sort of way, that would create possible issues for the Bill of Rights. The advantage of this regime, it deals with the polydrug use that has cumulative effects on behaviour, because there's no need to determine which combination of drugs contributes to the impairment. And all they need to do for the offence is to prove the presence of one qualifying drug. The disadvantages, I guess, that people raise is that it's subjective judgments of impairment. Now, you can mitigate that to an extent by having a set assessment process and requiring police officers to be trained and certified to do that, which is what we have. And it may only be useful for impairment that can be observed. The issue, I think, probably in an enforcement setting, it is time consuming. And certainly as far as the skills of the enforcement officer are concerned, it's not just a question of training, but they do require ongoing experience to conduct the impairment testing. And it cannot be used for drivers who have a physical disability, and I think I mentioned before the drivers who were injured as a result of the crash. This is the example that the Minister referred to in his presentation this morning. And it's unsuitable for roadside testing and random testing. You'd have to take the person to the police station to do the impairment test. I'm just going to say a little bit about per se limits, not a great deal, because I think there are people here who are probably more qualified than me to speak about them. It most closely resembles, I guess, the alcohol testing regime, and whether that's an advantage after what you were saying this morning. And I guess it bypasses the need to prove impairment in each case, but it does create some disadvantages and difficulties in that you'd have to set legal limits for each drug, and knowing where to set the legal limits is problematic when you want to set them in ways that reflect degree of impairment or crash risk. And I guess the issue is it does misalign with your drug control laws, which a number of people have spoken about this morning, if the legal limit is greater than 0 for illicit drugs. If we went to a presence, that's the zero tolerance approach, a presence-based approach, well, you could argue that it's objective. There's no need to, no requirement to prove impairment, and it does, I guess, avoid some of the legal issues, knowing where to set per se limits that are based on crash risk or impairment. And one might argue that it does align with your drug control laws for illicit drugs. And certainly it can be used for roadside testing if you use a roadside screening test of oral fluids, and it can be used in a random testing sort of way to enhance general deterrence, which of course is what the Australians have been doing for a number of years now. I guess people have talked before about, this point has been made before, that presence does not necessarily mean impairment, and you might be detecting people who were not impaired when they were driving. The screening devices are limited, and they tend to detect a limited range of illicit drugs, and the focus on illicit drugs, I think, probably ignores drugs that can impair driving, illicit drugs that can impair driving. And people have also spoken already about the policy challenges that this sort of throws up. Is this the regime about detecting and sanctioning impaired drivers, or is it punishing drivers for using illicit substances? And I think also the question comes up, is it really a drug control strategy in disguise that's using the roadside or a road safety intervention supposedly really to get at people who might be using illicit substances? We think in relation to the New Zealand Bill of Rights, it would create issues for us if you used it in a random testing application because of some of those factors. And the other disadvantage, I think, that we have to acknowledge is the cost. If you're doing a random testing application, it's going to be a lot more expensive than testing for alcohol, and certainly breath alcohol. And I think that does raise issues about opportunity costs. You know, would we get the best road safety outcomes spending the money there than perhaps using it in another way? And just to mention, that I'm sure that people are aware of this, there have been various operational issues with screening devices, issues concerning the accuracy with false positives and false negatives, although I understand the technology is improving. Some of the screening devices are susceptible to operator error. You've got to follow quite a prescriptive set of instructions to get an accurate result. There is the time taken to produce a result, and I think somebody from Queensland mentioned this issue about how long can you reasonably keep a person sitting at the side of the road. You know, given that the alcohol screening test takes a few seconds, 3 to 5 minutes is quite a long time. And then there are special requirements relating to transportation and storage. So I guess the final point I'd like to make is I haven't seen any single internationally accepted approach. People are using what regimes suit their political and sort of social cultural environment. And I think the chosen approach that we will, as everybody does have to do, is this careful balancing of a number of competing objectives. And of course there's road safety there's driver rights, particularly the Bill of Rights Act in New Zealand's case. There's technology capability, police enforcement practices, and the road safety spend, whether that is the best value for money. And we've got to do this review and come up with recommendations for the Minister of Transport by the middle of next year, so there's a lot of work to be done. And I think that's all I wanted to say at this stage. Thank you.